Independent contractor. Introduction. An independent contractor is a person employed to perform a specific work but who is not under the direct control and supervision of the employer regarding the manner of doing the work. The employer controls only the result and not the method. General rule. As a general rule, the employer is not liable for the torts committed by an independent contractor because there is no relationship of master and servant. Independent contractor versus servant. Independent contractor works under a contract for service. Servant works under a contract of service. Employer is generally not liable for contractor's torts. Employer is vicariously liable for servant's torts. General rule of liability. The general rule is that the employer is not liable for the torts committed by an independent contractor because the employer has no control over how the work is performed. Exceptions to the rule. Negligent selection of contractor, employer liable if an incompetent contractor is chosen. Non-delegable duties, duties related to safety cannot be delegated. Inherently dangerous acts, employer remains liable. Strict absolute liability, liability cannot be avoided by delegation. Statutory duties, duties imposed by law cannot be delegated. Case law. In Honeywell and Stein Limited v. Larkin Brothers Limited, the employer was held liable for damage caused by an independent contractor because the work involved an inherently dangerous activity. Position in India. Indian courts follow the same principles and hold employers liable in cases involving hazardous activities, statutory duties, and non-delegable obligations. Conclusion. In conclusion, the employer is generally not liable for the torts of an independent contractor. However, the law recognizes several well-defined exceptions to protect public interest and prevent misuse of delegation.